What happens when a lawyer's past statements collide with their future ambitions? Judicial confirmation hearings are supposed to be a sober assessment of a nominee's qualifications. But more often than not, they become a high-stakes game of political chess. It's a performance where every question is a potential trap, and every answer is scrutinized for hidden meaning. The real question isn't whether the nominee knows the law, but whether a senator can successfully paint them as a political ideologue unfit for the bench. This process reveals less about the nominee and more about the deep political divisions that now define the American judiciary. Let's look at the key exchange that reveals everything.
Mr. Chairman, Judge, Ms. Abudu, congratulations. I want to just talk to you, at least initially, a little bit about the law. Ms. Abudu, what's the adequate and independent state grounds doctrine?
Thank you, Senator Kennedy.
You're welcome.
In my practice, I actually haven't had an opportunity to use that principle or doctrine, but my general understanding is that it speaks to the fact that if a federal court is able to resolve an issue based on state law grounds, then that is what should lead in terms of the court's ultimate decision.
Okay. What is the selective incorporation doctrine?
That also, in the voting rights or civil rights context, is a term that I haven't had to come across. But what I do know is that as a legal research and writer, and for sure confronting possibly new areas of law, I look very forward to doing my due diligence in terms of making sure I'm familiar with doctrines such as that one.
Do you know what it is?
So no, I'm not familiar with it sitting here
Selective
today.
incorporation doctrine? Okay. Well, you're going to see a lot of it if you're confirmed on the 11th Circuit. Can Congress pass any law that the Constitution doesn't prohibit?
Based on the frame of your question, I would say yes, that sounds right.
So you think Congress has plenary power?
Well, I would first look to what the Supreme Court has said in terms of following precedent.
No, but I'm interested, if I could, Counselor, in your opinion. Does the United States Congress have delegated powers or plenary power?
Well, the Congress has both, I would say, from my general understanding. Again, it depends on the context and the issue, but it is.
Can you explain the difference to me between strict scrutiny and intermediate scrutiny?
Senator, strict scrutiny is the highest level of scrutiny that's often applied in constitutional cases.
What's the definition? I'm sorry, go ahead. Excuse me.
So it requires that a state, when enacting a law or regulation, have a compelling governmental interest for doing so, and that the law is narrowly tailored to achieve that interest.
Okay.
And then intermediate, did you say?
Yeah.
Okay,
yeah.
so intermediate speaks to the issue of having a substantial interest or an important governmental interest that is substantially related.
Okay. Do you believe that the meaning of the Constitution is immutable, or does it change over time?
Senator, I would say that the Supreme Court in some cases has analyzed that issue, and the response really does depend on the context and the issue. But what the court does or has done in its approach, of course, is look to the plain meaning of a statute or of the Constitution, because that really is where the inquiry should start. And if the language is plain, then that is where the inquiry can end.
Okay, thank you for that. You were involved in a 2021 report from the Southern Poverty Law Center about voting in Louisiana. Did you say, quote, racist white Southerners, close quote, and, quote, hostile white voters and governmental officials in Louisiana continue to make local polling places and early voting locations threatening spaces for black voters? Did you say that?
Senator, I do not believe that I said that. I haven't read that publication in
Will
some
you help
time.
write it?
I helped to draft the publication and approved it, but I'm not familiar with that
Oh,
language.
you don't, okay. In that same report, did you say, well, tell me where in Louisiana local polling places and early voting locations are threatening African-American voters? You said it, so which polling places?
So again, Senator, obviously I don't have that report in front of me to be able to read and remind myself of the examples that might have been shared. But what I can say is that Louisiana.
Let me cut you off because I'm going to run out of time, Counselor. Let me ask you one more. In August 2021, we're not talking 20 years ago, we're talking 2021, you were involved in another report by the SPLC. And you said that voter identification, photo ID to vote, is burdensome and does not serve any legitimate state interest. Do you really believe that?
Senator, identification for voting is
Yes,
something.
but first, do you really believe that? You said it. You meant it?
The Supreme Court in Crawford v. Marion County has already upheld voter ID laws as per se
Yeah, but you said it
constitutional.
didn't serve any legitimate state interest. Do you believe that?
Again, Senator, without that language in front of me, it's hard to understand
You
the
said it.
context.
Here it is, August 2021.
Well, there are
I'm just
cases.
asking you to explain to me why having to prove you are who you say you are before you vote doesn't serve, you said it doesn't serve any legitimate state interest. I'm just asking to explain that statement to me.
I understand, Senator Kennedy, and again, without being able to see the language that appears before and after, it's hard for the context.
You deny that you said it?
I can't say that I haven't seen that language in front of me, but what I do know is that there have been voter ID cases in which courts have found
But
that
I know, I'm familiar with the case law, but I'm asking what you think, because you may be on the 11th Circuit. Do you believe that voter ID is inappropriate?
my commitment is to uphold the Supreme Court's decision in Crawford v. Marion
I know, but
County.
here you said it was inappropriate. You deny that?
Well, again,
Saying it?
Senator, it would be helpful to know if that section of the report also cites to cases in which federal courts have found that certain voter ID laws do pose an burden on voters.
Thank you, Senator Kennedy. Senator Booker?
I'm going to yield to Senator Whitehouse, who's more
Senator
seniority
Whitehouse, more senior than Senator Booker.
and more hair.
Now, that's no reason to yield.
That's a big group, Senator Booker.
Let's test them in the 40, though, and see who wins.
It's kind of a clean sweep of the
On
committee.
something. We have a number of prosecutors who have chosen, in the name of social justice, not to prosecute an entire class of cases, despite the fact that their legislature has passed these criminal statutes. Do you think that's proper?
Senator Kennedy, I think I can speak to that issue very broadly in the federal context, based on my experience as a prosecutor.
I'm asking just in both contexts, state and federal. I'm asking your opinion on this conduct by some prosecutors.
Well, to phrase my opinion in constitutional terms, on the federal side, Article 2 directs that the president shall take care that the laws are faithfully executed.
Right.
It's long been recognized that there's a principle of prosecutorial discretion.
Let me stop you because I'm going to run out of time, as I think you're aware. Do you agree with what these prosecutors are doing, or do you disagree?
Senator, I agree with the principle of prosecutorial discretion exercised in the interests of the United
That's
States.
not what I'm asking, and we both know that, Counselor. Do you agree with what these prosecutors are doing, or do you disagree?
Senator, I would have to get a little more detail in order to opine on that.
Are you afraid to give me an answer?
Certainly not, and I'm happy to give you an answer.
Okay, could you give me an answer, Ms. Padine? Do you agree with these prosecutors, or as I described their conduct, or you disagree?
Thank you for that question, Senator. One would have to look at the position that the prosecutor is taking and why
I
they,
just explained it.
well,
Some prosecutors have taken the position, despite the fact that their legislature has passed a criminal statute, that they're not going to prosecute cases in violation of that statute. Do you agree with that or disagree with that?
Senator, I can tell you that if a criminal matter appears before me, I would apply.
I know you would, but I'm asking you your opinion on that prosecutorial decision.
But that's an area that really falls within the executive part of government.
Are you
to
afraid
be able
to give me an
address.
answer?
No, but I think it's a complicated answer.
No, it's not. Do you agree or disagree?
Senator, once again, I'm going to say that it's within discretion of a prosecutor whether to prosecute or not. The voters.
Will you give me an answer?
Senator, I am aware that prosecutors must act consistent with the 14th Amendment. That comes up in connection with selective
Yes, ma'am.
prosecution.
But do you agree with the prosecutors or disagree?
Senator, I do not, sitting here today, have an opinion on that. It's outside my practice, and it is
Have
not
you
something-
thought about it?
It is not anything that I have studied.
Are you aware of the issue?
I am aware of the issue.
And do you agree with the prosecutors or disagree?
Senator, I can tell you that I am aware this is hotly debated in the mainstream,
Yes, ma'am.
and
I'm asking your opinion.
legislators. I know there are positions on both sides. I have not refined an opinion on that.
Are you afraid to give me your answer?
No, Senator, I would give you an answer if I had it, and I'm doing my best to answer your question, but I do not.
Could have fooled me, Counselor. We both know what we're talking about here. I'm just at a loss why none of the three of you will give me an answer. It's very simple. Do you agree with the prosecutors or disagree?
The exchange you just saw is a masterclass in confirmation hearing strategy. Senator Kennedy isn't just asking random legal questions. He's executing a deliberate, multi-step plan. First, he establishes a baseline by asking about fundamental constitutional doctrines like adequate and independent state grounds and selective incorporation. When the nominee, Ms. Abudu, is unable to define the latter, a doctrine central to how the Bill of Rights applies to the states and highly relevant for a federal circuit court judge, it creates an immediate impression of a knowledge gap. This initial stumble is crucial because it frames the subsequent, more political questions. It allows the senator to imply that if the nominee is unsure about foundational law, perhaps her judgment on more contentious issues is also suspect. Then comes the pivot. The senator moves from abstract legal theory to the nominee's own published work, specifically her involvement in reports for the Southern Poverty Law Center. He confronts her with quotes about racist white Southerners and her claim that voter ID laws serve no legitimate state interest. Notice her response strategy. She doesn't engage with the substance of the quotes. Instead, she repeatedly falls back on the defense of not having the document in front of her or not being able to recall the specific language. This is a common tactic for nominees. Admitting and defending the statement would provide sound bites for attack ads, while outright denying it could be perjury if proven false. The claim of needing context is the safest middle ground, but it also creates the appearance of evasion. This is especially true when the senator points out the Supreme Court has already affirmed the constitutionality of voter ID laws in the case Crawford v. Slash and Mine. Marion County, making the nominee's past statement a direct contradiction of established precedent. Finally, the senator moves to a broader, philosophical question about prosecutorial discretion, the idea that prosecutors can choose which laws to enforce. This isn't just a random topic. It's a direct reference to the national debate over so-called progressive prosecutors who have chosen not to prosecute entire categories of crimes, despite those actions being illegal under statutes passed by legislatures. When Ms. Abudu, and indeed the other nominees, refuse to give a direct opinion, framing it as a matter of prosecutorial discretion, the senator repeatedly asks, "Are you afraid to give me an answer?" This is the checkmate move in his strategy. It doesn't matter what her answer is anymore. Her refusal to answer becomes the answer itself, allowing him to portray the nominees as unwilling to take a clear stance on a critical issue of law and order. The three key themes that emerge Are the nominees' alleged lack of deep legal knowledge, a history of activist statements that contradict established law, and an unwillingness to engage directly with controversial legal questions? This hearing is a microcosm of a much larger battle over the role of the judiciary and law enforcement in America. The question about prosecutorial discretion taps into a fundamental tension in our system of government. Legislatures, elected by the people, pass laws. The executive branch, including prosecutors, is supposed to enforce those laws. When a prosecutor decides, as a matter of policy, not to enforce a whole class of laws they disagree with, it raises a serious separation of powers question. Are they exercising reasonable discretion on a case-by-case basis, or are they effectively rewriting the law from the prosecutor's office, usurping the role of the legislature? Think of it this way. If your city council passes a law setting a speed limit of 30 miles per hour, but the new police chief announces they will no longer ticket anyone going under 50, has the law really just been changed without a single vote from your elected representatives? That's the core of the issue Senator Kennedy is pressing, and the nominee's reluctance to engage with it speaks volumes about how politically radioactive the topic has become. So, what are the key takeaways from all of this? First, confirmation hearings are rarely a genuine inquiry into legal philosophy. They are a form of political combat where senators attempt to define a nominee on their terms. Second, a nominee's past writings and associations will always be the most fertile ground for attack, forcing them into a defensive crouch where they must avoid either defending their past words or disavowing them. And third, the safest strategy for a nominee is often to be as non-committal as possible, deferring to precedent and avoiding personal opinions at all costs, even if it leads to frustrating and repetitive exchanges. This leaves us with a critical question. If nominees are trained to say as little as possible, and senators are focused on scoring political points, do these hearings actually tell us anything meaningful about how a person will behave once they have a lifetime appointment to the bench? What do you think? Let us know in the comments below. And if you found this analysis helpful, be sure to like, subscribe, and share this video.